Thank you to all the witnesses here today. I'll begin with the principle that I think everyone should agree with. No employee should be required as a condition of their employment to financially support a political agenda or a candidate that he or she opposes. This is an application of the First Amendment and a cornerstone of American liberty. The Supreme Court agrees. In Janus v. Ask Me, the Supreme Court recognized that federal employees' First Amendment rights are violated when employees who are not members of the union are forced to pay agency fees. The court said that such agreements violate, quote, the free speech right of non-members by compelling them to subsidize private speech on matters of substantial public concern. And given that government unions, everything they do have to do with matters of public concern, free speech would be violated. It is great that government employees' First Amendment rights are protected, but what about private sector workers? The Supreme Court case, Communication Workers of America v. Beck, partially protects employees from being forced to contribute to political causes they disagree with. But it is clear from the witness testimony today that Beck is not strong enough. At Cornell University, Mr. Rubenstein and his Jewish friends were continually harassed by their graduate student union for refusing to fund their affiliate union's pro-Hamas agenda. At the New York Legal Assistance Group, Ms. Mann and her Jewish colleagues fear expressing support for Israel in their office because of the anti-Semitic climate created by the union. Even though she was exercising her Beck opt-out rights. Mr. Taubman, you helped litigate CWA v. Beck. Why is Beck insufficient today for Jewish employees and those who, for other reasons, do not want to support their union's politics?
Beck is inadequate, first of all, because many employees have no idea that it exists and unions have no incentive to tell them, because if they find out, then the union gets less money. Second of all, look at what happened with UE at MIT. People filed Beck objections in 2004 and 2005, and the UE gave them financial disclosure from 2018 and 2019. 5- and 6-year-old financial disclosure. So how are people supposed to know what the union is doing with their money when the union won't open up their books to tell them? And I just want to address this point about right to work, that Congressman Courtney paints this as some kind of radical thing, right to work. It's called free choice in America. No one tells you what church to join. No one tells you to join the Elks Club or not join the Elks Club. No one tells you to join the AAA for your car. But federal law tells you, join this union, this Hamas-supporting terror organization, or we'll get you fired. And I could show you hundreds of threats to get employees fired. That's American, okay? Free choice in America to join a private organization. Unions are not government. Unions are a private organization, and I think it's a disgrace that any American has to fund a private organization that they don't want to.
And it's sometimes said that these unions have been chosen in a certification election, but many times that happened decades or even generations ago. Do you care to comment?
I think the last statistics I saw was that 90-some% of employees have never voted for the union that represents them. And even if they have, I can tell you from experience, trying to decertify a union is difficult, if not impossible.
And I think Mr. Rubenstein alluded to this, and you may know the law on this. I've not heard of this phenomenon before of having to go to your union and apply for a religious exemption. What's that all about?
So what that's all about is under Title VII, you have to show that you have a sincerely held religious belief. But who do you go to apply and prove that you have a sincerely held religious belief? The party that's forcing you to pay the dues. And that, in this case, it's either Cornell and or the union.
The party that's taking